from this minute. Olá, boa tarde a todos. Em Brasília, 14 horas. 10 a.m. Pacific Time with our dear Professor Tom. Gostaríamos de dar boa tarde a todos. É um prazer recebê-los. Eu sou a Valéria, eu sou a diretora da Mediar Paraná, que tem a honra de estar aqui hoje em parceria com a Tudo Sobre Conflitos, do professor e doutor Fernando Hoffmann. Nós estamos tentando trazer a vocês opiniões, experiências, ideias sobre o presente e o futuro dos métodos que nós consideramos mais adequados de solução de conflitos. Temos o prazer hoje de ter a presença do professor Thomas Stipanowich, que tivemos a honra de conhecer na Universidade de Pepperdine, no Straus Institute for Dispute Resolution, uma das entidades mais reconhecidas e recomendadas em resolução de conflitos dos Estados Unidos. Eu passo a palavra agora para o meu querido amigo, Dr. Fernando, para que se apresente e apresente o nosso querido professor.
Olá a todos, boa tarde, Valéria. Good afternoon, Professor Tom. So I will do a short introduction and I will go back to you, okay, Professor Tom?
Very good. Thank you, Fernando.
Thank you. Eu sou o Fernando Hoffmann, juiz do trabalho no Paraná desde 97, atualmente coordeno a Escola Judicial do Tribunal da 9ª Região, Paraná, e sou mestre em Direito em Resolução de Disputas pela Pepperdine, Instituto Straus, desde o ano passado, onde eu tive a oportunidade de conhecer o Tom. Desde já eu agradeço a Valéria pela parceria, nós estamos tentando disseminar a palavra dos movimentos adequados de resolução de disputas. Eu sou um entusiasta da ADR, tento aprimorar a mediação no tribunal onde eu trabalho e tento também disseminar o conhecimento sobre a ADR para a sociedade civil, a iniciativa privada, companhias, sindicatos e o público em geral, tanto falando sobre prevenção quanto administração e resolução de conflitos. E é por essa razão que eu criei esse website, Tudo Sobre Conflitos, .com.br, estão todos convidados, ali vocês vão encontrar alguns textos, alguns escritos e materiais para download. Agora eu passo a apresentar o nosso querido professor Thomas Stipanowich. Ele trabalha no Straus Institute of Dispute Resolution, onde ele ocupa a cadeira William H. Webster em resolução de disputas. Além de ser o diretor acadêmico do Straus Institute, ele também é professor de Direito na Pepperdine University Caruso School of Law. Tom leciona aulas e cursos de negociação, mediação, arbitragem, arbitragem internacional e resolução de disputas internacionais. Ele é pesquisador, professor visitante, palestrante e instrutor, tendo atuado em diversas instituições e faculdades dos Estados Unidos e do mundo. Ele já esteve aqui no Brasil várias vezes, já palestrou em Curitiba, falando na PUC, Paraná, em 2017, treina árbitros e mediadores em todos os lugares do mundo. Eu mesmo fui aluno dele em 3 disciplinas no mestrado da Pepperdine, e Tom vem conduzindo diversos cursos de capacitação e programas educacionais para empresas e escritórios de advocacia. De 2001 a 2006, Tom foi o presidente e CEO do International Institute for Conflict Prevention and Resolution, o CPR Institute, uma renomada entidade sediada em Nova York. Ele é conhecido por seus pares por ser um excelente árbitro e mediador, tem larga experiência como mediador, árbitro e facilitador de disputas cíveis, inclusive aquelas ligadas ao setor de construção, onde ele atuou e atua em casos complexos e em grandes obras. Diversos awards, diversas premiações ele vem recebendo ao longo da carreira. Só para citar uma delas, em 2008, ele recebeu o prêmio D'Alembert Raven Award, a mais alta honraria segundo a Comissão de Resolução de Disputas da ABA, a OAB local. Já dialogou e entrevistou várias autoridades, como, por exemplo, o arcebispo Desmond Tutu. Obteve, além de bacharelado, mestrado e doutorado em Direito, também bacharelado e mestrado em Arquitetura. Como vocês podem perceber ao fundo da tela da Valéria, nós temos Abraham Lincoln, desenhado pelo nosso querido professor Tom. Ele tem diversos escritos, é autor de diversos livros e artigos, e me permitam aqui citar 2. Eu tenho aqui na tela o primeiro deles, Arbitration Theory Practicing Law, muito bom, por sinal, e outro livro em coautoria, esse é um pouquinho mais substancial aqui, Resolving Disputes, também essencial para todos aqueles que pretendem se aprofundar na área. Além de artigos já publicados, eu sei que nós temos artigos no Prelo, livros no Prelo. Eu cito aqui que está por vir o artigo The Lincoln Way, The Evolution of a Master of Conflict, e também um que me chama bastante atenção pela área onde eu atuo, The Future of Consumer and Employment Arbitration. Eu fui aluno do Tom em 3 créditos, como já disse antes, e ele também foi meu supervisor acadêmico. Venho acompanhando o trabalho dele há anos e digo isso apenas para que vocês tenham certeza de que estão frente a uma das maiores autoridades em resolução de disputas dos Estados Unidos e do mundo. Essa é uma breve apresentação do nosso convidado. Vocês podem encontrar mais dados e textos deles no site da Pepperdine University. Agora vamos voltar ao Tom. Tom, now I come back to you. I have just made a short introduction of you and your work. I am so grateful you have accepted our invitation. Thank you so much. I was just telling the audience that I have been following your work, and that I am sure that we stand before one of the greatest ADR scholars. You are welcome. It's a pleasure to talk to you again.
Well, let me say boa tarde to you, Fernando, to Valeria, and to all of the people who are joining us today. I thank both Judge Hoffmann and Ms. Pinto for sponsoring this program and inviting me to lead off what I think will be a wonderful set of conversations. I do want to say before I go any further that I wish I could be with you today. I'm glad we can be together virtually online, but I would love to be in Curitiba. I would love to be in the lush green hills of Paraná and enjoying myself with you. And I hope that that time will come again soon. I fondly remember Curitiba and look forward to returning at some point. And I have good friends, including the 2 individuals who are responsible for today's program in Curitiba and others, and I look forward to seeing you. I want to begin by kind of laying the groundwork for our discussion by presenting a big picture here. You know, when I talk to lawyers and to students today, I try to remind everyone that our work in conflict management, dispute resolution, is like driving down a modern highway, a multi-lane highway. When you drive on the interstate here in California, you rarely stay in one lane. You move from lane to lane as circumstances dictate. Sometimes you may want to be in the fast, expeditious lane. Sometimes you want to be in the slow lane because you're very, very careful about arriving at a destination. Often you're in the middle somewhere. You may have a choice of 7 or 8 options. Well, that is the world we live in today. And that's what we want to talk about. And one option in particular, or in a range of options that fall under the rubric of mediation. Before we do that, I simply want to say that to one degree or another, wherever you live in the world, whether you're in parts of the United States or parts of Brazil or working internationally, you find that we all, to one degree or another, are looking for a range of tools, a choice of lanes. I like to say that instead of, although I used to call myself a litigator, I realized that that really wasn't accurate. For one thing, I did a lot of arbitration and still do. At the same time, I realized that most often things get resolved through negotiation, with or without the help of a third party. And that is most often true in the US and many other places through mediation. But I think we should refer, instead of talking about litigation or arbitration, I would propose we talk about litigation. That's one of my favorite words because we recognize that we're constantly changing lanes and that ultimately we may end up in a mediation or negotiation lane, and that gets us where we want to go. These are serious considerations. No matter what your background and your focus, your discipline as a lawyer or professional, this permeates all aspects of life. But for lawyers, these are essential skills for the 21st century. You know, I've been in practice of one kind or another for about 40 years, actually more than 40 years. And during that time, I have had the benefit of watching a revolution in the way disputes are being resolved and conflict is being actively managed here in the United States and other parts of the world. And certainly Brazil is coming to the forefront and making itself felt in terms of a variety of changes that are going on. We'll come back and talk about that later. I began to see changes from the very beginning when I was in my early days of law practice in the United States. Our Supreme Court Justice Warren Burger said, you know, we're not doing a very good job of tailoring process to the problem. We can do a much better job than we're doing right now as lawyers and as problem solvers. You know, the legal system has become too much of a one-size-fits-all approach. We need to try to develop different skills, different tools, different processes to deal with different needs in different cases. We also need to think about the fact that people tend to rely too much on lawyers to do everything for them, and they've lost the ability to deal in any way to engage in their own dispute resolution. That doesn't mean displacing lawyers. What it means is that people need to step up and be part of the decision-making process in a more effective way and actually help lawyers do an even better job. Instead of simply focusing on adversarial binary processes, we need to be thinking about other ways of looking at problems. You know, one of my favorite ways of thinking about a dispute solution is to think about a table. We often describe the fact that in an adversarial situation, you're on opposite sides of the table. And yet, in many cases, the way to get everything resolved is to somehow find a way to be on the same side of the table and look for ways that mutually acceptable resolutions can be made. And this is one of the things that mediation allows us to do. It also permits us to move away from formalized procedures, which automatically change the way people think about their relationships with each other and about the dispute. It usually creates a spiral of conflict the longer these things go on. And instead of focusing simply on our legal rights and our remedies, which are very limited, there's so many other opportunities for looking at interests, as we say, going below the line, going below the surface and saying, what's really going on here? What are the drivers of conflict? What are the hopes, fears, dreams, ambitions, concerns that motivate people, that motivate them to get into a dispute, and they also have hold the keys to getting out of disputes and resolving disputes. And of course, in Brazil, as in the United States, let's face it, we've got an issue. And with our current situation, which has multiple dimensions in the US, we're seeing that litigation is again becoming more long and more costly and more risky. And the question is, what do we do about that? The fact is, there are things we can do. Today, when it comes to litigation or arbitration, we've got a lot of choices. And it begins with the most flexible set of tools that I'm aware of. And that would be two elements. One is basic negotiation, which we'll come back and talk about later, and mediated negotiation, where a third party facilitates a negotiated resolution and may accomplish quite a number of other things along the way, including helping parties learn how to deal more effectively with one another in relational situations, like co-parents or joint venturers, business partners, people who are in the same workplace, employers and employees. There are all kinds of opportunities for using these flexible tools. These are options that are available to us. And this is not a homeopathic remedy. This is not like patent medicine. It's not meditation. It's a very, very serious set of skills that businesses and others need to be aware of. No 21st century lawyer, in my opinion, can be without these tools and these possibilities. So I'm going to talk about a variety of different topics here, and then we'll open up the floor to questions. And I'm going to move at probably a 30,000 foot level and raise a number of topics, talk about opportunities as well as challenges that I see in the U.S. experience and the experience that you were engaged in Brazil. We'll talk about relational approaches and the special needs of relationships. My background, as you may have heard, was as a construction lawyer, specializing in complex construction disputes. And from the very beginning, I came to realize that conflict is something that needs to be managed. We'll come back and talk about that later. We want to talk about the opportunities for mediation and other approaches to resolve disputes early and effectively. We might have the opportunity to touch on combinations of approaches. Again, the multi-lane approach to dispute resolution. I want to touch briefly on negotiation skills and insights. We're learning all kinds of things about the psychology of conflict, the way you and I and our brains evaluate a situation or fail to evaluate and simply leap to a resolution of some kind or a posture without really thinking through things. And I can't, in the present or present past, no discussion of the future of dispute resolution is appropriate without talking about online approaches digitalization, electronic tools, which is starting to affect all aspects of our lives. You know, let me share with you that one dynamic that continues to play a part in the United States, even after 40 years of change and progress, is that many lawyers and some clients are very, very cautious about embracing new tools. I heard one lawyer who represents a lot of companies say, you know, companies, my clients tend to say they don't want to be the first person to cross the street. They'd rather cross in a crowd with everyone else. They don't want to be a guinea pig, an experimental animal. They want to know that something is tried and true and it works well. I'm happy to report that when it comes to mediation, we have considerable data and evidence that mediation for businesses, for families, for individuals, for professionals, can be an enormously valuable approach to getting a negotiated resolution, and it can occur at any time in the dispute resolution process, before litigation or arbitration, during adjudicative processes, after, during appeal. There's always the opportunity for seeking a negotiated settlement and asking a mediator to come in. Now, there are a whole variety of entities that had a role to play in change in the United States. We started with some community justice centers that began to experiment with mediated dispute resolution. Their success paved the way for court-connected programs in our federal and state courts all over the United States. Administrative agencies embraced these same approaches. We also had a whole variety of NGOs and nonprofit institutions, the American Bar Association, National Institute for Dispute Resolution, the Association of Conflict Resolution, and of course the organization that you heard Fernando mention that I ran for a number of years and continue to be involved with. It's known as CPR, the International Institute for Conflict Prevention and Resolution. Many of you are familiar with CPR because it's doing work in Brazil right now. And among other things, it is offering some of the same tools that were very instrumental in getting businesses to look more closely at a whole range of approaches for resolving conflict out of court. It started with a pledge. It started with an idea that was embraced by literally hundreds, eventually thousands of companies and law firms to say, we pledge that we will look for ways of trying to informally and effectively and early resolve conflict. And when two pledge signers had a dispute, they could point to the fact that they had both made this commitment as a way of getting a negotiation started. Now, negotiation might not occur right away, but they knew that sooner or later there'd be an opportunity, perhaps with the input of a mediator. CPR and other organizations developed many standardized agreements, templates, and I'll touch on this a bit later, which today are ubiquitous. You know, some years ago, and you may have heard me talk about this, CPR, Straus and Cornell University co-authored a study. And we were doing a follow-up on an earlier study that had been done by Price Waterhouse and Cornell on what major corporations, the Fortune 1000 corporations, do in terms of dispute resolution. What we found was that in 1997, companies were these are big companies, were beginning to embrace mediation in virtually every area of dispute resolution. Any kind of dispute, other than a criminal case of some sort. And even there, we could talk about the role mediators might play, or at least a negotiated settlement. But the whole range of civil disputes were amenable to mediation, and companies were beginning to use mediation. Well, by the time we did our study several years ago, the follow-on study, virtually all of the responding companies, I think 98%, said, yeah, we use mediation, and we usually use it in a whole variety of different kinds of situations. So it's such a flexible tool. It makes so much sense. Do you know that in the United States, based on some research, some qualitative research that's been done, I think a lot of attorneys, and this may or may not be good, actually depend on mediators to get a negotiated resolution. They want that mediator there. And there are a whole variety of reasons why that may be. And we'll talk more about that later. In other words, what we've seen is that there has been something of a shift in law practice where lawyers say, you know, I'm a negotiator and I think I'm a pretty good negotiator, but I think there are things that a mediator can do that I may not be able to do by myself. And that is a really, really significant insight. So why has mediation become the great success story of the quiet revolution and dispute resolution in the United States and increasingly in a number of other places? One is, of course, control. And that means different things to different people. I know that lawyers are very concerned about being able to manage conflict and manage the conflict resolution process. Mediation allows that in all respects, both in terms of managing the process, managing the final result, getting to a place that may be better than you could ever get in a court or an arbitration. It's also an opportunity to engage parties. You know, mediators talk a lot among themselves, and I know we have many mediators on our call today, about the role of engaging parties, not just the lawyers themselves, but actually engaging the parties in the conversation, trying to determine what the real drivers of conflict are and what might best suit the parties in terms of a tailored resolution. We know there are a lot of things that mediation can accomplish, integrative terms of all kinds, ways of restoring a relationship that has foundered, ways of improving a relationship, maybe even creating new business entities, or engineering an apology, which often is worth a lot to people who have been wronged, who have suffered injury, or tailoring other creative solutions that may do a much better job than damages, or that supplement damages and really make parties whole in a way that they never could be with substitutional relief given by a court. So you have an eminently customizable process. Let me mention something that about CPR. You know, back in the 90s, when I first began to learn about CPR, the organization I eventually ran, at the time they were dramatically promoting mini trial, which was an informal process where two decision makers for the parties would come together along with a mediator or facilitator. They would hear best case presentations by their respective lawyers on a very accelerated basis, maybe a few hours, maybe a day or two at most. And then they would come together and try to reach a negotiated resolution with or without the help of the mediator. Now, what's interesting is this was very much the focus of activity back in the 90s. Well, it didn't take very long before mini trial ended up being considered really a branch of mediation, or at least it falls under the rubric of mediation. Why? Because mediation can mean many, many different kinds of processes. Any kind of facilitated negotiation process. It might involve some element of evaluation. It might involve presentations of different kinds. So many opportunities here. This is what I love about mediation. Mediation means many, many different things and can be tailorable to many different processes. Mediation also is a great cross-cultural bridge. It is a terrific way of not only serving as an agent of reality for parties, but also really getting to the nub of conflict, which sometimes is about a failure to communicate. And that can be a barrier as a result of culture, which might be organizational culture. I once mediated some disputes within a construction company, and I found that the 4 different departments of the company were constantly at each other's throats because they used different language. They couldn't communicate effectively. They misunderstood each other and they couldn't serve each other's needs. So these are things that mediators do all the time. The one thing I will leave you with, and I hope the mediators don't feel that I'm going too long in terms of promoting the benefits of mediation, but I will say, the way I look at mediation is that normally, if I have an opportunity to mediate, I want to take it. Why? Because there's a tremendous opportunity that sooner or later, the mediation will produce a negotiated resolution. If it doesn't, I've spent a little bit of time and money, but I can continue in the lane that I was in before. So it's really, to me, a win-win kind of approach. And I think this is very, very important to keep in mind. Now, one thing that I do want to point out is that courts have a critical role to play in beginning to develop a culture that embraces mediation. In the United States, I will say that beginning with a number of judges who saw the opportunities presented by mediation, people like, for example, Judge Fernando Hoffmann, we began to develop this idea that mediation was an acceptable alternative and that it had the opportunity to create success stories. And I saw this with my own eyes. I began to mediate in the court system. I began to take cases with guidance of a court. In other words, a court would say, I think this case would be amenable to mediation, would ask the parties if they'd be willing to try it. And we began to develop success stories. We began to create opportunities where parties who had been in a divorce or divorce posture and couldn't even be in the same room together began to meet with the help of third-party mediators. And at first, all they could do was barely bring themselves to get together for a second meeting. At the second meeting, things began to happen. Gradually, they developed a co-parenting statement to help address the needs of their children and their interests as parents, and of course, addressed all of the other aspects of the divorce process, and created a basis upon which to continue working together. So, I saw immediately that there was a qualitative difference in what could happen as a result of a negotiated resolution with mediators involved. First, just to begin to open parties' minds, begin to put, instead of just generating more heat between the parties, putting light on the situation. I love that metaphor, and I often feel that when I'm working with parties in mediation. I also remember some of the early cases where you had people, again, who where there had been great injury, someone who had been fired from a senior position at a company. And it turned out that the feelings, which had generated very strong claims in court and extended litigation, actually could be addressed if the parties could get together and simply have a face-to-face talk with a bit of understanding about where both sides were coming from. It was a family company. The person who had been fired had been there in the beginning and felt like he'd been kicked out of the family. It was only when the new young president, the second generation leader of the organization, had an opportunity to talk with this older gentleman that they came to understand each other. An apology was given. They came together that day. They worked out a way of moving forward with a consulting arrangement for the older gentleman, and they had dinner together. That's not something that normally happens in litigation. but I've seen this over and over again. That's not to say you always repair a relationship or that you can do more than arrange a negotiated damages settlement. But nevertheless, there are so many opportunities there. I must say, before I continue, that it's important to note, we said mediation can make can be very different depending on the circumstances, because it is a tailorable process. Another thing to keep in mind is that when we talk about mediation, we may have different starting points based on our culture and our legal tradition. Let's face it, both the United States and Brazil have long cultural traditions and legal traditions, a certain amount of expectation that goes with dispute resolution. We have to deal with this. And what I've discovered is that in particular, attorneys have certain ways of looking at things. Now, some years ago, we did a study of mediation or mediators and their work in different parts of the United States and in different parts of the world. And I think one of the most striking things that we discovered was how different default practices of mediators might be depending on where they live or where they practice. To some extent, this may be a result of differences in law practice and the expectations of lawyers. For example, here in Los Angeles, for some reason, there is great emphasis on the caucus. That is, on separate individual meetings with the parties. Usually the information that is exchanged, much of it is kept in confidence, may never be shared, or it may be depending on the understanding. But the fact is that in LA, there is a much greater tendency to use caucus more extensively than in even other parts of the United States. And this is a very interesting thing. Why would that be? Well, it really caught me by surprise. And in fact, I have to tell you that when I first presented the data, it was at a national meeting. And we almost had a fist fight among mediators, believe it or not, because you had people with different ways of approaching problems. Some said, well, you know, I also use joint sessions. And others said, well, I'd use whatever approach I think is appropriate to the circumstances. And why do you say caucus is always the preferred approach? So this is the kind of discussion that we need to keep having. We all develop our own preferences. We may be led to develop a particular approach by the people that we work with. And the question is it always the best approach? I think whatever we do, we want to be very deliberate about it. And this is part of why we're having this conversation today. We want to realize mediation is just full of choices. We have quite a few options of how we approach the process. And with that, let me take you into the world of online dispute resolution. I don't know how many of you have had an experience where you have actually had all or part of a mediation or even an arbitration online. I will tell you that over the years, I have watched electronic media become more and more a part of our processes. We all work constantly online using email or other media. We also, in an arbitration hearing, there may be a whole variety of different electronic tools that we use that I've now become commonplace. What has not developed as quickly as it might have is the whole idea of having a mediation online, that is wholly online as we are right now, or an arbitration online. And there are a whole variety of reasons for this. And I can give you some good reasons why we would perhaps prefer to be in the same room together. And I talk a lot with lawyers and with students about this as we begin to reflect on what the possibilities are. And in fact, currently, I have a mediation scheduled for early July. And the party, and I will tell you that as a result of coronavirus, things have slowed down because lawyers have become much more deliberate and much more careful about how they're doing things. And so while I'm encouraging them to try to think about some elements that might be done online, there's still a real thirst by many for and desire for a face-to-face process. And so I will be going down to Orange County in early July to mediate a complex case there. So, you know, the fact is, I continue to be open-minded about the possibilities, but I have to recognize that we have to bring people along. And I'm happy to talk more about the pros and cons and opportunities and challenges of online processes. I know for a fact that some judges in Brazil are extensively using online processes right now. In fact, one of my friends I was just speaking to this week said that he expects that virtually all of his cases are going to be online for the present, given the circumstances that we're all dealing with. And Fernando may say the same thing. But I think in private dispute resolution, and informal dispute resolution, do keep in mind that there is a range of choices associated with electronic media. And I guarantee you that as a result of the current realities that we're dealing with, we are never quite going back to where we were before. We're in a new world and we need to deal with this. And that does not mean that online is always the best solution, but it may be at least a partial solution for certain circumstances. So be aware of that. You know, I want to talk about one other area of opportunity here before I conclude, and I'll try to touch on 2 or 3 things. But as I mentioned to you, I tend to work a lot in relational conflict, construction and engineering disputes, which evolve in the context of jobs that may be going on for years. And you may have ongoing projects in which a dispute has arisen and threatens to derail the project, and sometimes does. There are 4 sobering truths about this kind of dispute. First of all, conflicts in a situation like that tend not to get lower, they tend to mount, they tend to intensify. Related costs do not tend to go down, they just increase. Finding solutions becomes more difficult and complicated as parties become more staid in their positions. They move into litigation mode. And as a result, a job progress may be delayed or disrupted. Relationships may be stressed and maybe out the window, and business goals for everybody undermined. So in light of this, and I'm grateful that I've had this opportunity, you know, the parties in this arena, construction and engineering disputes, tend to want to resolve conflicts more quickly and cost effectively instead of going down the long road of adjudication. We did a poll with one of my former law firms. We did a poll of corporate counsel who work with different companies doing construction, owners, contractors, design professionals. These are mainly big companies. They said that an efficient, cost-effective dispute resolution process was the top business priority in dispute resolution. Now, I sometimes talk with my arbitrator friends and lawyers about arbitration. I've done a lot of arbitration over the years. And one of the things I've observed both domestically and internationally is all too often arbitration is becoming more and more like litigation. It takes longer, it's more costly, it is more formalistic. Every aspect of it is extended. It is more legalized. And for that reason, I'm not saying again that arbitration may not ultimately be the direction one has to go. But I would suggest that throughout arbitration, there are opportunities. Perhaps before the process begins, perhaps early in the process, midway through the process, before hearings begin, or late in the process or even after it. So, businesses are looking for things like getting on with business, maintaining control over the process and the results in dispute resolution. They do want fairness, although it's not always measured in terms that lawyers would use. It may be in a business sense, in applying business custom and not strict legal technicality. They may want privacy and confidentiality, and they may want to get that business relationship back on track. So these are all things that they want to be thinking about. Which processes you opt for and when is crucial. This is the thing that I try to convey to practitioners and to students, to say, when you get into this process, again, you constantly have opportunities to shift lanes. And one of the broadest and brightest lanes and most effective lanes is mediated negotiation. And that's why it has taken on such a huge role in, for example, construction dispute resolution. Many of my friends who are my co-neutrals at JAM say, Tom, do you still arbitrate? And I said, well, I do arbitrate some, yeah. They said, well, several of them have said, I've gotten away from that. I don't find it satisfying. And so often parties are frustrated at the end of the day with the resolution. At least somebody is not going to be happy. And even if they so-called win, it may take so long that they're frustrated. Said it's so much better and nicer and more satisfying to help them resolve a dispute more effectively early and come up with something they have a part in developing. One thing that I want to mention, we talked earlier about contract templates that have been developed by leading organizations, and these are being used all over the world. But we might want to talk more, not just in this call, but in this webinar, but long-term, about multi-step dispute resolution. I can tell you that this can play a huge role in a variety of different kinds of dispute resolution. In the construction arena, for example, you might have a stepped process in which sometimes called an escalation ladder, where you start with very simple, informal, direct negotiation. You might kick the negotiation up at some point to senior management, but this can be done at an early stage, maybe without intervention by third parties. But the fact is that at some point, lawyers may become involved, and at some point, it may be critical, sooner or later, to have a mediator. I think there are good reasons to have provisions for early negotiations. I also want you to think about putting a mediation provision in a contract. I'm not saying that it will always work out the same way. There are reasons why you would have an escalation process. You start with informal, you start with direct, you start with less costly, more private, earlier, and then you begin to move down the line. And at the very end, you may find yourself in an adjudicative process. But there's always an opportunity, always, for a mediated resolution. The fact is, as we said, that can happen anytime. There's a debate, however, among lawyers and some mediators about where mediation can be effective. I will tell you that there are some lawyers who say, well, yes, I know that I'm going to mediate, and I actually want to mediate, and I think I usually prefer a mediated resolution. It nearly always is better than going all the way through litigation, nearly always. However, I prefer to wait until I've got all the information exchanged, I've got everything laid out on the table, and frankly, my client has gotten tired of the process and is ready to settle. You hear this, but I will tell you there are some other people who say, I'm thinking of a particular friend of mine who said, Tom, I often will be brought in early under a stepped clause, or sometimes just as a result of the post-dispute agreement of the parties. And at that point, he said, I seize the opportunity as the mediator. I take hold of that. I work with the lawyers. We exchange necessary information. Sometimes I might evaluate in some way, or we might get a judge to make a ruling or an arbitrator to make a ruling. But I nearly always can get that thing resolved earlier than it could have been otherwise. And he said, so I really do think it's important to at least give parties the opportunity to mediate. The great thing is you can always come back and mediate again if mediation doesn't work the first time. It need not be an expensive or risky venture. But my own preference would be, generally speaking, people should think about providing for or considering early mediation. So that's something to keep in mind. And remembering mediation is always available, but it should be something more than a whistle stop on the litigation railroad. It should be, it should have meaning in itself. And at some point it will. And I think early mediation needs to be considered. Coming back to our notion about relationships, Dwight Golan, who is an outstanding mediator and a professor as well, who's trained many mediators, did a study some years ago about mediation in relational situations, all kinds, family disputes, business disputes, etc. But this is a situation where the parties in dispute had or have some kind of relationship. And the question is, what is the impact of mediation? Now, this shouldn't surprise you, but here's what Dwight found out. He said, well, I came to realize that one of the most important things is how quickly the mediator can become involved. And whether or not the parties, the decision makers, whether they're, husband and wife, co-parents, or business people, whether they can be involved and actually engaged in trying to structure the resolution. These are key points. The timing, how quickly after a dispute arises, before dispute spirals, conflict spirals, can a mediator get involved, and who are they dealing with? And frankly, how critical is the relationship? And that determines whether or not a relationship can be salvaged, whether or not the parties can create creative terms or integrative terms. So these are things to keep in mind. I want to briefly mention, again, going back to my construction arena, somebody that I recently got to know who is the director of a program pioneered by Intel Corporation. Intel had a stepped dispute resolution process. And just like I've described, they had negotiation, then mediation, followed by arbitration or litigation. They said, we can do better than this. We could develop a program where we have someone with mediation skills who can develop the trust of parties and actually work with a risk management team, with team members from all the major parties, owner, contractor, and other groups, to consult on appropriate options for looking at the progress of the project, looking at developing concerns, and then with the neutral actually helping to facilitate resolution, or maybe helping create processes to resolve the dispute. So this is something that I think we want to talk a lot more about. I will tell you, I know that in Brazil, recently the government created new opportunities for the use of a real-time dispute board process on public works projects. This is something we can talk more about. It's another kind of real-time relational dispute resolution process. I think these things have tremendous potential. And I really do want to emphasize that. I want to conclude with a statement, and we can talk more about some of these things, but I'm curious to know what you're thinking about and what you'd like to ask. Before I do that, let me conclude with one thing. Abraham Lincoln, who, as you know, is a great hero of mine and many Americans, and for good reason, spent some time during his life being very introspective about his law practice and about his life. And he actually wrote a lecture for other lawyers, his peers. He said, we're trial lawyers, but he said, I think we should tell our clients we want to discourage litigation because often the winner in court is a loser in terms of the time spent, the fees spent, just how they feel when it's all said and done. He said, as a peacemaker, lawyers have the ability to be better people. He also said, this is actually the best way to get business. There will always be business enough. A satisfied client will come back, will recommend other people to you. It's just like a doctor. If there is a way of managing disease, dealing with disease or the development of disease proactively, isn't that what a doctor wants to do, rather than risk the most expensive surgery? There may be a combination of approaches, but these are things we need to be thinking about. I offer all of these comments, my own experiences and those of many colleagues, really as a way of stimulating discussion. I know that you are all in your own experiential process. We're all at different phases in different cycles, but we have much to learn from each other, and I look forward to learning from your experience. Thanks.
Thank you so much, Professor Tom. So now I ask Valeria. Valeria, do you want to make the first question?
Actually, first, I'd like to thank our dearest Tom for all these words. Tom, I have absolutely nothing to say, but thank you so much. It's always a pleasure to hear from you and from your experience. I think that's what we need. We need to know it works. We need to know it is a better way. You know, here in Brazil, I feel that since I got back from Pepperdine, we are talking a lot more about ADR, about mediation, negotiation, arbitration, but still too little to learn from. Our judiciary system is working much more towards it, but I still think that the private mediation is the right answer. Because as you said, we do need judges. We do need them to judge. We do need Fernando to know what he's doing as a judge. And it's important that he has this other way to look at things. But lawyers are still embarrassed, let's put it this way. They are not really sure that if they bring mediation to their clients, that the client will look at them as a good professional. Mm-hmm. So these many roads that you presented us are essential for us to learn that there are many ways to get to a better end. And I really thank you for that. I would like, we have this unique situation here where you have a lawyer and a judge talking to you at the same time. And we would like to present you some difficulties here in Brazil with mediation and ADR itself. Mm-hmm. Fernando, how would you like to ask and answer to Tom how can you help us lawyers get past these difficulties with our other lawyers at the Bar Association? How can we make them see how good of a path this is for our work, for the best way for us to talk to a client, and how can they be sure that it is a good way to make money? Let's put it this way, because here in Brazil, normally the clients think that if you suggest an easier path, it's because you're not that good of a lawyer. And at the same time, you don't earn all that you charged for the job. So how can we make all these arrangements so the clients believe in the work we are doing? It's difficult for us to trespass that barrier, to tell the client that it is going to be a better end if we try this road.
Tom,
would you like?
And let me add something. You said that courts have a critical role to play, and I totally agree with you. I recall one of your classes, and you told us about a party that went to courts looking for justice, and she told you that she found just ice. I don't know if you remember that, but I clearly remember that. So let me add the following question. How the American judges deal with mediation, and what would you say to Brazilian judges about mediation?
I think judges are in a unique place to be able to understand, frankly, the limitations of legal process. By the time a matter gets into court, there's a very limited range of remedies that courts may be able to administer. The same is true, frankly, of arbitration most of the time. In the US, and to some extent, I know in Brazil, you also have the issue of just the amount of time delay associated with litigation, the fact that it may go on for a generation in some cases. And there are a lot of risks. It's often hard to tell how is this case going to come out. And judges understand this. I think, again, are in a unique place to really fix on this. I think that efforts can be made by the courts and by judges to actively encourage mediation. I know there have been discussions about the kind of approach that was taken in another country in South America, where there was a requirement that cases be mediated, civil cases be mediated in advance of litigation. I'm not arguing for that necessarily. I don't know that is the solution, but I will tell you that New York, the state of New York, are one of the two biggest commercial states in the country, and New York City, our major commercial city, has just said they want to mediate civil cases presumptively. So they're really going to that point. Now, this is after many, many years of experience with different approaches to mediation. And now the courts are saying, we've seen so much of mediation and the impact that it can have. And we've been able to compare it to our experience with litigation. And rather, they had some very fine-tuned, they'd come out a couple of years ago with a proposal for a much more fine-tuned system where they say, well, consider the following factors. if you're a judge as to whether you should direct a case to mediation or encourage the parties to mediate. Now they've thrown that out. They say, no, we think everything should, generally, the presumption should be mediation unless there's a good reason not to do it, which is just sort of flipping everything on its head. That should tell you, here is an experience of decades with the process, at least 20 solid years of experience with mediation. And they're saying, this is right. We're going to presume people should mediate before they come to court or early in the litigation process. And we'll try to help connect them to a mediator, or they can get a mediator of their own choice. But we really believe in the process, and we believe that it should be employed across the board, except where there's a good reason not to. That, to me, is one of the most powerful statements. I could use many examples, but that's a recent one. And just, to me, it's huge. So I would say, I think judges are just part of the solution. I think there have to be success stories, and they have to be discussed and promoted. And there will be. It's just a matter of doing it. We have to get those first people to walk across the street with able mediators. And once they walked across the street, then the crowd will follow. That's what's happened in the United States. And I truly believe that. I know that our systems are different in some respects. I understand that, there are many factors that come into play here. And I'm the last to say that mediation is always the solution. It's not. But as solutions go, it's probably, alongside unassisted negotiation, it's probably the best one we've got because of its flexibility and all the other characteristics of it. That's why I feel so strongly about it.
Okay, thank you for the answer. Valeria?
Thank you, Tom. We just need to find that courage one that will cross the road to be followed. Daniela here, Daniela Souza, she wants to know, what would you say among all the mediators' competences is the most essential one? What do you think? What would you say is the most important characteristic for a mediator, for a good mediator?
I would say the number one requisite for a mediator is the ability to develop rapport. That would be my own choice. And it took me a while to figure that out. I think rapport is critical in all aspects of life, but it's central to what mediators do. Rapport, developing rapport and trust, developing the confidence and trust of the parties, because you're going to be drawing on that trust account. You can only succeed if they can rely on you. And so you need to be able to be in a position where not only, hopefully, they like you, but at least they trust you and they have confidence in you. And I think that's really, really critical. Rapport, trust. I will follow that by saying another piece of that is persistence and patience. And those are also very critical. Being willing to stick with it, keep trying, keep encouraging the parties, keep moving things forward, keep at it, but also have patience and don't assume you're the whole solution. So those are some of the things that loom largest in my mind.
Okay, Tom, and you know that my last unit in the LLM, I attended at the UNONS, the United Nations, in the Ombuds office.
Yeah.
And I went there and I could see that we can apply mediation skills, techniques in prevention and in managing conflicts. So we can use it at the workplace. What can you tell us about that companies? I know that you have researched this subject, the Fortune 1000 survey approaches this. How do you see the use of ADR at the workplace?
Let me say that in my experience, and I'm not a specialist in employment or workplace disputes myself, but just in my my study, I believe that the workplace is probably the single most fertile ground for the development of conflict management techniques, not just mediation, but a whole variety of different approaches. And in fact, some years ago when I was heading CPR, we did a book on different systems, different programs that companies had developed in the workplace. And what's very interesting is that in such circumstances, you might have all kinds of different approaches. You might have, a hotline where where employees could call and say, "I need to talk with someone about a problem I've got." You might have different kinds of peer review. You might have an ombud who's outside the main system, who is able to help manage conflict in an informal way. You might have mediators, either embedded mediators or mediators from outside, private mediators who are brought in to resolve disputes. What's interesting is that by the time you look at all those kinds of programs, companies that have developed these multi-pronged processes often do not have much litigation or arbitration at all, because they can get everything resolved in a more informal way. And so although we didn't talk about it before, the whole system of employment and workplace disputes is just an immensely fertile ground. And this is an area where I think able mediators can create a lot of opportunity or take advantage of a lot of opportunity.
Thank you, Tom. Valéria?
Thank you, Tom. Doroteia Azevedo is greeting you from Salvador.
Great to hear from Doroteia. God bless.
She wants to know, what's your advice for attorneys in Brazil concerning mediation?
My advice is to try it. My advice is to learn about it. Try to find a training where you can actually practice mediation. You can try it out and see how it works and become more familiar with it, but it needs to be part of your toolbox. It is unfathomable. I know, again, we have different cultural backgrounds, to some extent, different legal traditions. So I don't want to say that the experience and the opportunities or the challenges are the same there, but they are similar. And the fact is that mediation is such a terrific tool. And it's an opportunity for lawyers to be their best. How can you serve the whole client without embracing mediated negotiation? I just don't think you can, because it fills a gap between unassisted negotiation and adjudication. There's a huge gap there, and there's a great need for intervention of some kind a lot of the time. So, to me, it's common sense. Why not do it? Why not try it? And keep an eye out for opportunities. So, but I'm you know, again, I think lawyers need to embrace that opportunity.
Yeah, I think, yes, we do have different legal systems, but I think we do have conflicts.
Mm-hmm.
The conflicts put us together,
Yeah.
you know, and we must solve them. We
Mm-hmm.
must resolve them.
That's very true.
I think this is the similarity between us. Fernando, anything else?
Yes, we have Silmara Ferreira asking, in this new reality, the virtual mediation, do you have any special recommendations for the good rapport?
And following, Luciana also wants to know, talking about rapport, she wants to know, how can a mediator build a great rapport?
Yeah, I will tell you that I have done a lot of teaching online over the last 2 years. And I believe that I am as good or better at establishing rapport in an online environment as I am if I'm face-to-face with you. When I'm looking at you, you know, it's like I'm sitting across the desk. And it's, you know, there's a lot you can do. Look, I'm using my hands. I can be just as expressive. We can talk in a confidential setting, and there are ways of dealing with some of the concerns about security. There are issues that, you know, the different systems are trying to come to grips with. But there are issues with any form of mediation or dispute resolution. And the more I do online, the more I'm convinced that I can be just as effective there in many settings. That doesn't mean that people always want me to be online. Just as I was saying, they may feel very, very strongly, particularly older people, particularly people, you know, who are nervous about going out right now. And maybe I have to go there. But I'm at the same time, I think that the future is going to be different. We're going to think about things in a very different way. And I think we need to begin to develop these tools and find ways of overcoming concerns about the differences and really take a problem-solving attitude toward it. But I do think, you know, rapport is about human interaction, expressing care. You know, the way you look at someone, eye contact, your tone, the way you use your body, you know, all of the forms of communication. And actually, as we get more sophisticated online, it's just going to be more and more like what we used to be used to. So I have no doubt that that is the direction we're going.
Thank you, Tom. Fernando.
I don't know if we have more questions, Valeria. I have.
You know, I may need, my wife may be expecting me to join her here in a few minutes, so I'll probably need to wrap up fairly soon. But I hope that we've answered at least most of the questions that people had.
Yes, I think we did. We can, if anything is left, we can just email it to you later and we'll get back to the...
And I'm very happy to. Yes, I should mention that we're actually headed to visit some friends today in a different city, and we have an appointment. But I will tell you that nothing could please me more than to follow up on this conversation. It means so much to me to be a part of your ongoing discussion. And, you know, you're all in my heart. I'm thinking about you and hoping and praying the very best, not just for you individually and for your families, but for the evolution of these wonderful tools that we've been talking about, and for you to use them to their utmost.
Thank you. Thank you, Tom. We are just so glad you accepted our invitation, our humble invitation. I had the most wonderful experience in Straus with you and everyone else. Pepperdine is a great place for us to learn exactly what dispute resolution is about, and get the best of it from the best ones at it. So
well, we want everyone to know that they're welcome. We would love to have you come and visit us there. And as I said, I look forward one day to returning to beautiful Curitiba and saying hello to all of you there. But thank you again for including me.
Thank you so much for having us. It's great to be there at Straus Institute with you and Pepperdine. Fernando, will you wrap us up? Thank you,
Yes.
Tom. It was great seeing you again.
My pleasure.
Tom, thank you so much. If people ask me who is Thomas Stipanowich, I would answer Tom is an educator and one of the best I have seen. I want you to know, Tom, that I am very happy today. It was the first online conversation Valéria and I have. ADR has so much room for growing in Brazil. Your presentation was excellent, and I am sure that our listeners and watchers will take advantage of your wide knowledge. It was an honor to have you talking to us. You were so kind by accepting our invitation, and you always were looking for meeting our expectation, and you surely did. Wow. I thank you so much. Today, is Valentine's Day in Brazil. So my regards to Sky. I hope you have a nice and romantic Valentine's Day. It's always a pleasure to speak with you. Be safe. And I would like to quote a person that you admire and you have at your background. And let me start. With malice toward none, with charity for all, with firmness in the right as God give us to see the right, let us strive on to finish the work we are in, to bind up nations' wounds. Abraham Lincoln's second inaugural address, 1965. Tom, thank you so much.
So good to be with you. Thank you. Thanks again. It was wonderful.
Thank you. We hope to see you soon back in Pepperdine.
Look forward to it. Yes. Welcome. Take care, everyone. Bye-bye.
Thank you.
Best
you too.
Wishes. All right.
Thank you.
Fernando, eu agradeço esta primeira de algumas que teremos. Agradeço a participação de todos que estiveram conosco. Vamos providenciar as legendas dessa nossa primeira conversa sobre ADR, essa primeira de uma série dessa parceria que nasce agora entre Mediar Paraná e Tudo Sobre Conflitos. Afinal, o nosso objetivo comum é ampliar o alcance, ampliar as informações e trazer as experiências para que possamos traçar caminhos tão promissores e bem-sucedidos quanto os que ouvimos agora. Muito obrigada pela confiança e parceria, meu amigo.
Valéria, muito obrigado a você, né? Você, desde o primeiro momento, se esforçou bastante para que essa parceria desse certo e, graças a Deus, tudo foi muito bem. Então, agradeço todo o seu empenho. Gostaria de agradecer também a todos que nos assistiram e a todos que também divulgaram esse evento. Não podemos esquecer também de agradecer ao Felipe, que nos ajudou com a parte técnica, né, nos permitindo que a conversa do Zoom fosse transmitida via YouTube. O vídeo estará disponível tanto no canal da Valéria, Mediar Paraná, quanto no Tudo Sobre Conflitos.com.br. Também iremos colocar material relacionado. O Tom tem vários artigos publicados, não há necessidade de assinatura, ele disponibiliza isso e realmente é um aprendizado muito grande. Ele tem diversos artigos, alguns citados inclusive pela Suprema Corte norte-americana. Quem está começando a estudar e quem já está estudando há algum tempo o ADR, é extremamente recomendável a leitura da obra do nosso querido professor Tom. Valéria, muito obrigado.
Obrigada a você e obrigada ao Felipe, como você bem lembrou, graças a ele deu tudo certo. Muito obrigada a todos, excelente final de semana e até a próxima.
Até logo, bom fim de semana.